Hello, everyone, and welcome to Legal Matters, an informational and news call-in show devoted to legal topics of interest to you, the State Line viewer. I'm your host, Alan Jones, and with me, attorney Michael Crosby with the Crosby Law Firm. We have attorneys standing by now to take your call at the number on your screen, 815-397-2006. They'll provide you with free information on your legal issue. The call is confidential, so pick up the phone now and call the Crosby Law Firm throughout the next hour. Again, that phone number is 815-397-2006. Now, on our opening statement for this episode of Legal Matters concerns what can be done when a person is faced with a complex legal situation. The outcome may not be as clear-cut as you may believe. And in the second segment, we'll also continue our popular You Want to Know question and answer session devoted to questions posed by you, the viewer, via telephone calls and social media. Again, the number is 815-397-2006. Lawyers are standing by right now to take your confidential call. But before we get started, please note that the Crosby Law Firm represents thousands of individuals just like you. Just as our local hospitals handle a multitude of healthcare issues, the Crosby Law Firm can help you with a multitude of legal care issues as well. So please pick up the phone at 815-397-2006. The Crosby Law Firm has a Center for Divorce and Family Law, an injury department which includes but is not limited to auto and motorcycle accidents, as well as a slip and fall, medical malpractice, workers' compensation, and Social Security disability matters. There's also a Bankruptcy Institute, an office for DUI, traffic and criminal defense, an advanced care plan and probate center, and a division for real estate, business matters, and more. So again, feel free to call and discuss any of these practice areas with the attorneys standing by at 815-397-2006. Lawyers are standing by right now to take your call, and a reminder, it is free and it is confidential. So Michael, welcome to the show. Always a pleasure to see you.
Thanks, Alan. Glad to be here.
Got great information, as always. I know a lot of times when we've talked about many of the legal issues that you see in your office, they seem to be somewhat cut and dried, very specific. But there has to be times when clients come with very complex legal issues that requires a lot of work and research on your part. How do you handle those kind of things?
Good question. We've been doing this now upwards of 40 years, not our first rodeo. We've learned over time, and we've got lawyers in our office, a combined experience well over 150 years. That said, there are issues that we're confronted with virtually every day by clients that are not cookie cutter, are not simple, are rather complex, complicated, and may not be a straightforward, easy answer. You come to our office for a divorce, that's pretty straightforward. You come to us with an auto accident, that's pretty straightforward. But there can be matters that are more complex. So over the years, we've developed, and we've really launched it this year with great success and with much gratitude by clients, a new practice area, and that's what I wanted to discuss today. In the practice area, we label it research and investigate. Very similar to a visit with a physician. They call it a lab workup. Same concept. To give you an example, if you visit with a doctor and you inform the doctor that you've got a stomach issue, stomach ailment, your stomach's hurting. Doctor, what's wrong with my stomach? Please solve the problem. The doctor's liable to say to you, it could be an appendix, might be a gallbladder, could be an ulcer. He's not quite certain what the proper diagnosis is. So the doctor will suggest that he walks you down the hallway at his clinic to the laboratory, where they'll perform a series of tests, a urinalysis, a blood workup, perhaps an ultrasound of your stomach. When those lab results come back, the doctor is now in a better position to diagnose what the issue is. Same concept in our office. We don't call it a lab workup, and frankly, we're not quite as expensive as a lab workup. We call it a research and investigate. So if a client visits us with a complicated issue, before we just kind of go off willy-nilly and try to immediately diagnose what it is, we'll tell the client we need to do our own lab workup, what we call a research and investigate.
Okay, so what's the process in going through all that? Obviously, you get all the facts concerning the case, but where do you go from there?
Just as with a physician's office, there may be a pathologist that oversees the lab workup, an MD. In our office, we have an attorney with a great deal of experience, been doing this for a number of years, who devotes almost all of his time to diagnosing these issues, developing a game plan, if you will. Just as you might get a written lab workup back from the laboratory, in our office, once we take on one of these projects, we'll provide for you a memorandum that will include the facts of the case, the analysis of the law, the regulations that might apply, and suggestions as to how we should proceed. So we'll prioritize things from 1 to 2 to 3, so to speak, and bring some clarity to the issue to help the client. Many clients come to us with many complicated issues, and they're looking for problem solving. They're also looking for clarity, and they're wanting the lawyer to help them sort out and prioritize things. And that's what we do with our research investigate cases.
Sure.
It's met with a great deal of success. Clients, this year we've probably opened up in excess of 75 research and investigate cases for the first 9-10 months of the year.
Wow, that's busy.
Yes,
busy
yes.
indeed. Give us quickly. Give us an example. What would be a case involving this research and investigate?
Recent one that we took on regards a senior citizen who's now in an assisted living facility, and there's some issues as to whether that person qualifies for public aid or whether they should pay for the assisted living facility at the retail rate, so to speak. There's a home involved. There's some securities accounts, et cetera, et cetera. So before we can sort out what should happen with the client's assets, we need to research the regulations. Some will call it, there's a marketing name for it called Medicaid spend down. It may not be as simple as it looks. Perhaps the client does qualify for public aid and some of their assets can be exempt, house, so forth, or maybe they can't be. Perhaps there's an adult child that continues to live in the house, and so that child will be affected if you had to sell the house and take your proceeds and apply them to the assisted living facility. Perhaps the client doesn't belong at a certain kind of assisted living facility and belongs at a different kind of assisted living facility. So we'll sort out the public regulations, the law. We'll sort out the client's assets, the client's debts. We'll also sort out the client's medical needs by conferring with the doctor to sort out what kind of facility would best be suited for the client. That's a good example.
Okay, so there's a lot of steps to it and a lot of work that needs to be done by your firm.
Yes.
Okay. We'll talk more with Michael in just a moment. Again, that number to call is 815-397-2006. Stay tuned for our rapid fire You Want to Know question and answer segment coming up after a break. Welcome back, everyone. Again, in the first segment, we were talking about a new practice area of the Crosby Law Firm, research and investigate. I know, Michael, you wanted to wrap things up a little bit on that issue.
Sure. What I want to convey to the viewers is that while these issues can be complicated, we try to bring clarity to it. I want to make sure that our viewers understand that while these issues are complicated, we provide a free initial consultation. And so I would encourage them to call. If they've got what they think is a complicated issue, the initial consultation free of charge. Most of the time, when we take on a research and investigate project, we typically charge a flat fee. So the client knows what the budget is. The client knows where they stand. It's not a moving target. So we typically do not charge by the hour. And we think, given the complexities of the issue, the typical charge is rather competitive, and it certainly enables the client to crystallize the issues that they're going to be confronted with when we give them the research investigate, which then leads to the part 2, to solving the problem, to taking care of the surgery, if you will,
Sure.
if it's a gallbladder versus an appendix, et cetera. So what I want the viewer to understand, Alan, is that it's a free initial consultation. It's a flat charge for the research investigate, and we really find that it brings clarity to the client's life who has these difficult, complex problems. So I'd encourage them to call.
Fantastic. Thanks for clearing that up.
You bet.
On that issue as well. Another issue I know you want to talk about, near and dear to your heart, an event that the Crosby Law Firm's involved in.
Sure. You're talking about the Youth for Christ 5K run. October 14th, I would encourage the viewers to check out the Crosby Law Firm website for more information on it. It's a wonderful cause. What I want the viewer to understand is that the runner's fee, contributions that they may want to make, all of that's on the website. I would encourage them to go to it. The Crosby Law Firm is partnering with the American Law Firm with the help of Mark Brennison, who will be on the program later. And the two law firms together are paying for all of the expenses connected with the event. That's our way of sponsoring the event, so that all contributions from the event itself all go immediately to Youth for Christ. So It's a great event, helps a lot of our area's youth who need that kind of help. Wonderful program. We'd encourage viewers to check out the website and to come to the event. There's a 5K run in the morning at Midway Village on October 14th, which is a Saturday. And then following that, there's a picnic at our office. We provide all kinds of food and beverage, music. There's a silent auction. So I'm charged. It's the second year we've done it. My son Tyler, who's a lawyer in our office, along with Mark Brennison's daughter, Chloe Brennison, the two of them are kind of spearheading the event and really bringing a lot of energy to it. A couple of millennials who have come back to Rockford and are really trying to make a great contribution.
Yeah, good for them.
Yeah,
good for
absolutely.
them. And it was pretty successful last year, if I remember right.
Last year was the first one. This is our second annual one. So we had over 100 runners last year, raised about $10,000, and we expect to do much better this year.
Fantastic. Fantastic. Well, best of luck.
Yeah, thanks for asking about
best
it. Appreciate
of luck. And do want to kick off. This is our rapid fire question and answer segment. You want to know. In an effort to protect viewer confidentiality, understand we only use first names. We may alter the location and the nature of the question somewhat. And I would like to remind you that lawyers are standing by to take your call now, no matter the topic, 815-397-2006. So, Michael, the first question comes from Nicole in Winnebago. She says, my boyfriend had asked me to marry him. It is our second marriage for both. We each own houses, have pensions. He has some significant debt. I'm expecting an inheritance later on this year. What should I do to protect myself?
Well, first and foremost, congratulations to Nicole. I hope the nuptials, the wedding goes great, the marriage is great. What we're really talking about here is the need for a prenuptial agreement. Before these folks get married, they've got inheritances, they've got children, they've got other assets and debts, and there should be an effort to sit down with the two of them and work out an agreement. In the unlikely event that the marriage goes south and breaks up with a divorce, there's a roadmap as to how to divide things up. If that were to happen, it'll minimize the expense and the anguish connected with the divorce. It can be a cold prickly, kind of an uncomfortable or awkward thing to do. But for a couple who's on their second marriage, that have children, have assets and debts, it's imperative that they take a look at this. So we, again, free consultation. When we do a prenuptial agreement, it typically carries with it a flat charge as well.
Okay. Second question from June in Loves Parks. She says, I lost my job earlier this year. I've been making money selling homemade baked goods. My neighbor's been helping me deliver the product, taking up our baked goods on social media. We've been sharing costs and profits. Now we think opening a shop can be a new career for both of us. What should we do about starting our new business?
Very good question. Even if it's a smaller enterprise, this couple should examine whether they should incorporate a Chapter S corporation, an LLC corporation, perhaps a partnership might be better. Most of these enterprises, small as they are, should typically be a sub-S corporation or a limited liability corporation. We have a department devoted to small business startup. Do a lot of that work. Lord knows we need that in our community, Rockford. So I commend these two for their entrepreneurial spirit. I would encourage them to call. Again, the consultation is free of charge.
Okay, thank you very much, Michael. That's all the time we have right now with you. Don't forget, lawyers are standing by for another half hour after the show. That number to call, 815-397-2006. When we come back, Mark Brennison and the American Law Firm in just a moment. And welcome back to Legal Matters, everyone. I'm your host, Alan Jones, and with me now is Mark Brennison, the managing attorney with the American law firm. This is a half-hour informational news call-in show devoted to a variety of legal topics. Attorneys are standing by now to take your call at the number on your screen. They'll provide you with free information regarding your legal issue, so call now and throughout the next hour. Our opening statement for this episode of Legal Matters involves personal injury. We've been talking with Mark about personal injury issues for several episodes now. We're going to continue that. The number to call, 815-394-1776. Lawyers are standing by right now to take your confidential call, so call right now. Mark, pleasure to see you as always.
You too,
Thanks for
Alan.
being on the show. And we have been talking about personal injury, and Mark has written a series of books about personal injury and some facts and things to know about that. This one is called Personal Injury 101, the Non-Attorney Guide to Injury Cases in Illinois. The subtitle, I like that. The insurance companies are the real ambulance chasers. We'll talk to you about that one too.
Yeah, a lot of information in there. Think of how many episodes here that we
have been talking about this for several months, as a matter of fact.
A lot of information in that book.
There is. And part of that information is highlighted as myths you might have heard from friends, neighbors, and relatives. People always have something to say about your particular issue and what they've heard and what they've read, possibly Facebook. You never know where the source is coming from. So we'll start with some of these myths that you're talking about. If you send the careless person's insurance company a letter and ask for a reasonable amount, you'll get a reasonable settlement amount. I mean, almost there's common sense involved in that too, I think.
But we have many clients come in that will say just that because they tried to handle it on their own. They thought everything was going to be fair because their neighbor or their brother-in-law or their sister or their mother told them, hey, I did it and everything went really well. They don't know that the settlement that they got, their mother, brother, or whoever got was probably way lower than they should have. And they come in and said, the insurance company really was mean to me. They were nice up front, and then when it come time to try to settle up, boom. No, we're only going to give you X amount of dollars. It doesn't even cover your medical bills. And the insurance companies prey on that. They have, for years, back in the 1950s, started disseminating information to the general public about personal injury cases. And part of that is stay away from a lawyer. The reason is they make more money, bigger profits, bigger bonus for executives. And if they can get the common man that's out there, like you and me, to believe that they're going to be fair, that's money in their pocket, money out of your pocket.
Okay. If the insurance company requests a recorded statement and you refuse to give them one, they do not have to settle with you.
That's baloney. I never let a client give a recorded statement. I shouldn't say never. There are a few occasions where I will. But over 30 years of practice, rarely will I let a client give a recorded statement. And they say, well, we won't settle. And I say, fine, we'll just sue you and we'll let the jury decide. So ultimately, they have no control. The question is, do you have a competent attorney that can get the case to court, to a jury, get the information to a jury so they can make a good decision? And that's the key. So no, the insurance company doesn't have the last say. You basically do by filing suit. And they'll tell you that, and I can't tell you again how many times I've had people that have come in and they've been trying to handle a case on their own, and that's the exact thing I hear. Hey, they won't settle, or we don't have to do anything unless you give a recorded statement. Something commonsensical says, maybe I don't want to do that. And so they'll come in and ask, say, no, you don't have to do that. Maybe they won't settle, maybe you have to sue them, but you can force them to pay you without giving a recorded statement.
Yeah. Well, there's something, I think, in the power and the intimidation factor dealing with an insurance company.
They're big.
That they're big and you're not.
Yeah, they're
it's that simple.
multi-billion-dollar companies that have endless resources, and their adjusters are trained. So, you know, you're in an accident, you don't know anything about personal injury law, health insurance law, and they're coming and telling you what you can and can't do. You think they're going to tell you the truth when cheating you out of money will increase their bonus at the end of the year? No, not going to happen.
Okay. All lawyers who advertise that they handle personal injury cases have the same ability.
No, definitely not. There's a lot of attorneys that will advertise, TV, billboards, whatever, that have never been in the courtroom or they'll advertise to get the personal injury cases in, and then they'll find an attorney once they can't settle it who can handle themselves herself in the courtroom, and they'll refer the case to them, and then they get a cut. I'm not saying that's good or bad, but it's better to go to an attorney from the get-go, and here's why. If you're a litigator and you actually take cases to juries, you're going to know what information you need to get right from the get-go and preserve it so it doesn't go someplace else and you lose your case because evidence that was there is no longer there. To have an experienced attorney, an experienced litigator attorney who knows how to do that from the get-go is very important. I've had cases come to me over the years from other attorneys, and I can't prove liability because the key witnesses are gone. They didn't investigate it, send a private investigator to talk to them, get their telephone number, addresses, because they move. And you want to keep up with them, so if they move from Illinois to California, you can still get in contact with them. So it's good to have somebody that's experienced and not somebody that's not.
The insurance company of the person who hit you must pay your medical bills as they become due.
No way. To them, there's no way they want to pay your medical bills. Here's why. If you're going to the doctor, and let's say you don't have any health insurance, and nowadays the doctors, hospitals will, even if you have health insurance, they won't send the bill to the health insurance because they have to take the discount rate that they've contracted to take with your health carrier. So they want to send it to the at-fault carrier and get more money. So they won't, but when they don't get paid, they're still calling you to be paid, even though they have a source over here, your health insurance company can pay them because they want more money. Agreed. So bottom line is the at-fault carrier, the insurance company for the guy that hit you, they do not want to pay your bills because they want to put you behind a financial 8-ball. Creditors are calling you. You have a mortgage payment that's due, or you're 2 mortgage payments behind. So you'll settle for a lot less than what you should to save your house.
Just to pay your bills.
Just to pay your bills.
Right off the bat. We're talking with Mark Brennison, Personal Injury 101, his book, The Non-Attorney Guide to Injury Cases in Illinois. And we'll be right back. Don't forget, lawyers are standing by for another half hour after the show airs. Number is 815-394-1776. And welcome back, everyone. I'm your host, Alan Jones. With me is attorney Mark Brennison with the American Law Firm, and you're watching Legal Matters, an informational and news call-in show devoted to a variety of legal topics. Attorneys are standing by now to take your call at the number on your screen, 815-394-1776. They'll be able to provide you with free information on your legal issue. Call is confidential, so pick up the phone now. Call the American Law Firm throughout the next hour. Again, the number is 815-394-1776. And we've been talking with Mark about personal injury cases and instances of how to deal with a personal injury case. We've been going over this for several months. He's written a series of books about it, and one of them is called Everything You Need to Know to Protect Your Rights and Receive a Fair Settlement. So this is great information, and all of these books are available at the American Law Firm.
Free of charge.
Free of charge, so you don't have to worry about that. We have been talking about settling cases, but there is the instance, in fact we were saying about a quarter of the cases may even go to trial. So what do people need to know about the jury and the trial aspect of a case, a personal injury case?
Okay. First off, insurance companies set their settlement values for any particular type of injury. So if you have a rotator cuff tear, if you have a broken bone, if you have soft tissue, they all break it down by jurisdiction. If it's in Winnebago, Cook, DeKalb, whatever county you're in, they will know that this soft tissue injury in DeKalb is worth this much. Generally, juries return verdicts for this much for this type of injury. So that's how they set their settlement value. And if you aren't represented by an attorney, and they see that, part of that value then is going to be cut way down. And I typically see people that have come in and received an offer from an insurance company and they have not retained an attorney. It's probably 15, 20, 40% of what they should have gotten. And that's on the high side. Some maybe 5 or 10%. And,
wow.
so you need to understand, you need to have the ability to get the case to a jury for the insurance company to give you fair value for your claim without having to try the case.
Okay. So they should bring, a client should always bring a settlement, take it to an attorney,
Yes.
to the American Law Firm for evaluation.
That's right.
Is there a case where it ever is a fair settlement?
Rarely. In fact, I have never seen a case where somebody is brought in and presented to me what the insurance company has offered, given their injuries, that has been what they should have received. I've always gotten more for them. I've just never seen it. I'm sure there are, but I've never seen it in my experience, which means it's very little. But here's the key. Understanding what it takes to try a case is important. If you can't settle up, even if the attorney can't settle the case with the insurance company, because they believe juries are going to do them favors. They believe juries are with the defendant, not the plaintiff. They believe juries automatically, from the time the trial starts, believe that the plaintiff is out to get money. They're greedy. And a lot of times that is the case, because I've had people that have sitting on juries come in and retain me to represent them in a personal injury case, and they have said, we were sitting in the jury room getting ready to hear the case, and that's what they're talking about. There's already a preconceived bias. And they're now, since they've been on the jury, they said that's how they're looking at me.
Yeah.
Tough. So the jury trial process is this. First off, you have discovery and you find out about the case and you lock everybody into their story, and then you present it to the jury at trial. What happens is you select the jury. You get to ask potential jurors questions, and you're looking to get 12 people generally on the jury. And what people don't understand is when they return a verdict, all 12 jurors have to agree on the amount. If they find there's liability and the defendant's at fault, then they go to damages. All 12 of them have to agree on the amount. And that's where the rub comes in, and the insurance companies know it, because they can always find one or two jurors that will dig in, and they will not want to give fair value for the case. And so that's why they'll push trial, especially in certain jurisdictions, because they know they can find one or two jurors that they don't care, even if it's a legitimate injury. They will not give fair value to the case. So you have 10 jurors that want to give X, and you have one or two jurors that want to give X divided by 3. And that's the key. That's what you're fighting. So if you're trying to settle this case on your own, you're fighting that big process.
That whole system.
You're fighting that whole system. And so if you don't even have the ability to get the case to the jury, because you don't know the rules of evidence, civil procedure, if you don't know how to get the case to the jury, why should they even come close to giving you what the value of your case is?
Okay. We could talk about this for a long time,
Yes.
and we'll continue to talk about this,
Yes.
I'm sure, but our time has come to an end now.
Yes.
Mark, thank you very much.
Thank you.
Certainly appreciate your time. And don't forget, lawyers from the American Law Firm are standing by now to take your call, no matter the topic. Advice is free. 815-394-1776. They'll be available for a half hour after the airing of this show. We'll be back with a closing statement in a moment.
Legal Matters has been brought to you by the Crosby Law Firm and American Law Firm.
In closing, I want to encourage you to pick up the phone and call the attorney standing by. And because of the high volume of calls, attorneys from the American Law Firm and the Crosby Law Firm will be taking calls for another half hour after the show ends. If you get a busy signal or go to voicemail, keep trying, or just leave a message and either law firm will return your call the next business day. Thanks for watching Legal Matters. We hope you found it informative.